Hi, I'm Anna Denton-Jones of Refreshing Law Limited, and in today's session I'm going to be talking about the issues that arise when employees wish to record disciplinary hearings and other meetings with their line manager. Now, I'm sure you've all come across a situation where an employee is asked if they can record a meeting, and your instinct is probably to say no, that won't be necessary because we're keeping a meeting minute, and you're entitled to keep notes as well, and we can always do a compare and contrast to make sure that those notes of the meeting are accurate. But often the issue that arises is that employees, of course, have probably got a mobile phone with a recording device on, that they can surreptitiously record meetings without perhaps the person conducting the meeting knowing that that recording is taking place. And of course, it then gets brought out in evidence later on. Now, that happened in a case called Amwell, which involved a teacher and the governors of a school and a local authority. And what she'd done is I think, left her handbag in the room, and she'd recorded not only the disciplinary hearing itself, but she'd gone on to record the deliberations of the panel when she'd left the room and they were trying to decide what penalty to apply. And the issue for the employment tribunal was whether or not that evidence, the recording, should be admissible in the employment tribunal hearing. Now, they looked at a number of different issues. Of course, the employer was shouting from the rooftops about things like data protection and lack of consent of the people who were recorded, and breach of human rights and the right to privacy, and those sorts of issues. And what the tribunal said was really that you look at this in two ways. The first being the actual disciplinary hearing itself, and their view was that actually it's an open meeting. Nothing really should be being said or done in that meeting that you're not happy to have thrown back at you at a later stage. So there was it wasn't an expectation of privacy as such, and that any recording that was made would be admissible. When it came to the panel having their deliberations, and that was a different matter because they felt there was a reasonable expectation that that meeting was taking place behind closed doors, just amongst the panel themselves. So ordinarily, that recording would not be admissible. But there was a big caveat to what the Employment Tribunal said, because they said that if there was evidence of discrimination in that recording, then that would trump that expectation of privacy and make it admissible. So really, anyone conducting hearings or meetings ought to conduct themselves in a way that they're not going to be unduly concerned if a recording does emerge and comes back to them. So I certainly always advise line managers when I'm doing training to assume that they are being recorded and conduct themselves accordingly, and then that way you're not going to be unduly concerned if a recording emerges. Contrast that with a number of cases that I've acted in where managers have, shall we say, perhaps not conducted themselves in the best way, and then of course once a recording emerges we end up having to settle the tribunal claim because it would be very embarrassing to have that recording aired in a tribunal. The other issue that I'm sometimes asked about is whether or not you as the employer should record a meeting. Now, there's nothing to say that you shouldn't, but I would signal caution in that area again. The reason why I'm saying that is because if you conduct a meeting for, an hour, that recording, when it has to be transcribed then for employment tribunal purposes, is going to involve the person doing the transcription typing out every and every and every paper page being turned, and you end up with 150 pages of document, whereas obviously if you did meeting minutes you'd cut all that out and it'd be a lot shorter, so it can make it quite cumbersome, and tribunal bundles huge and those sorts of things. So I pretty much suggest not doing it. I hope that helps. If anybody's got any questions, please do not hesitate to contact me on adenton@refreshinglawltd.co.uk. Thank you very much.